All right, welcome again, or welcome for the first time. We're really glad you're joining us here for a discussion about After Loper Bright. So I want to just introduce the leaders of this discussion. We have Professor Matthew Stephenson. He's the co-author of a legislation and regulation casebook with Foundation Press, and Professor Jody Freeman. She's also a law professor at Harvard Law School. Without further ado, I'll let them take it away. And keep in mind too, this is a discussion, so feel free to ask questions, provide commentary. It's very, very informal, and we're so glad you're here. So thank you.
I guess we should talk now. Hi, everyone. It's nice to see, I think, a bunch of familiar faces and some new faces and some things that are not faces, but that are names on black screens. So great to see you all or be aware of your presence. I'm Matthew Stephenson. I'm one of the co-editors of the Legislation Regulation Casebook. As Tessa said, this is really not, I don't have an extensive presentation, neither does Jody. This is really just meant to be a conversation among those of us who teach this material about what our approach is going to look like in this dramatically changed world, and a world that's probably going to continue to change over the next few years. I assume that most or all of you use the Manning Stephenson book, or you probably wouldn't be on this call. John and I used to casually refer to chapter 5 of the book as the Chevron chapter. And of course, we can't refer to it that way anymore, at least not in the same way. So as some of you know, if you've already seen it, one of the things that I did over the summer while John was busy being the provost of the university, Jody is showing it off, thank you, is to do a revamped version of chapter 5. The most significant change of which obviously is at the end, it has Loper Bright as a principal case, and then some extensive notes on Loper Bright, written within a few months of the decision. And then there's also been a substantial overhaul of the rest of the chapter, incorporating a little bit of new material. I think there's some more in the book now on the pre-Chevron cases, which may be more relevant now in a Loper Bright world, and cutting back, though not entirely eliminating, the Chevron material. So I think this year is going to be an especially challenging year in which to teach this material. I think with each succeeding year, we're going to get more lower court case law, maybe potentially eventually another Supreme Court case or two. And so I think over time, the amount of that we'll probably be doing pretty regular supplements. Tessa, we haven't discussed this explicitly yet, but I think that's probably part of the plan, because the chunk of the chapter that's still the Chevron material is going to shrink. And the chunk of the chapter that's the post-Loper Bright material is going to expand. But we kind of don't know what that's going to look like yet. We're just going to have to see year to year what happens. So for what it's worth, for my part, I think the way I'm planning to teach this material this year is kind of the geological layers approach to it. I think I'm going to have to lead off this unit of the course explaining to the students that a lot of what we're going to be doing for the last 3 odd weeks of the course is legal history of a sort, at least the first 2 of those weeks, and explain that we're going to see how the doctrine in this area develops, so that when we get to where the doctrine is now, we'll be able to have a better understanding of the contemporary debates by understanding sort of how we got here. So those layers would be, in my mind, the kind of pre-Chevron world. I'm not going to go back to the founding of the Republic, but basically the cases from the post-New Deal cases, the 30s and 40s cases like Gravy, Powellhurst, the NLRB, and Skidmore. Then layer 2 on top of that is kind of Chevron Golden Age era. Like, what was it? What was the justification? What were some of the issues about its application? Then sort of the third layer on top of that, I sort of think of the decline and fall of Chevron before it's officially overruled. So starting early on with cases like Meade, which gives the step 0, and then working through that progression up through major questions doctrine, which is in the sort of intermediate zone where it technically precedes the overruling of Chevron, but can be thought of as a sign that the scope of Chevron is going to be limited. And then that last layer on top is going to be Loper Bright, which is what I plan to end with. So that's my plan for teaching. And when we get to Loper Bright, I think part of what I'm going to do is to ask the students to explore how this change in the standard review might affect some of the cases that we learned that were decided in the Chevron era. So for example, at least for now, I'm probably going to still give them MCI versus AT&T. I'm definitely still going to give them Chevron itself. And I think it will be worth thinking about in a Loper Bright world how would those cases look different? So that's my brief capsule of what I'm thinking, but let me turn it over to Jody, and then let's open it up for general discussion.
You won't be surprised, I think, that to hear me say I'll take a similar approach, in that I will teach the old progression, the pre-Chevron cases, maybe, like you say, Matthew, with a little more attention to it, Powell, and a case I never would have taught otherwise, and then Chevron, and then the fall. But I guess the one wrinkle I would add here is, I used to teach some cases that were about canons of construction, and I think, Matthew, you and I talked about this a lot back in the day, canons of construction and Chevron being in the same case, and how did the canon of construction fare when Chevron was at play? And I'm not going to do that anymore. So there's some material which some of you may have taught, if you taught those cases, whether it's Swank, the Clean Water Act case, or DiBartolo, and I'm just dropping them. And the other thing that I may not spend much time on at all is Mead. I think this is just a matter of dealer's choice. Like, there may be some things you want to summarize for the students and not teach, and make trade-offs there. I'm going to teach FDA versus Brown and Williamson, because I want to teach an old case that sort of is what I would call the foundational case about the major questions doctrine. And then, I'm probably going to teach both West Virginia and Loper. So it's handling the major questions doctrine and Loper Bright together, and then being able to talk about both and setting them up is what I'm concerned about doing. So I don't know if that's terribly different, Matthew, than anything you had planned.
I mean, a little different in some respects. I think I'm going to keep doing MCI, and I'm probably going to not do Brown and Williamson, which has been converted into a lengthy note at the beginning of the major questions section, no longer as a principal case. The thing on Chevron and canons, so it used to be that DiBartolo and Swank were principal cases. I think Rust v. Sullivan was as well. When I had to make some judgment calls when revising the book, because I didn't want to leave everything in, but I also didn't want to get rid of everything. So, it sometimes just had to make some calls that may or may not be right for all teachers. What I did with the Chevron and canon stuff is just convert it into a lengthy note that you could either assign or not, depending on how much time you want to spend on the pre-Loper Bright set of issues about the application of Chevron and disputes over how Chevron interacted with other tools and techniques of statutory construction. I could see an instructor spending some time on that, even though we're in a post-Chevron world, because it sets up issues that will become relevant later. I can also see an instructor wanting to drop that entirely, because what's the point of all the, epicycles on epicycles with respect to Chevron doctrine when it's no longer the governing framework? I guess, you guys and other people who use the book, I imagine, will be people who will supply a steady source of input. Some of you already, that I see on the call, have occasionally sent in user notes about things you would like to see added or dropped in the next edition. And I think this will be an especially
Rick Hells. He's looking at Rick Hells.
Yeah, possibly. No names. Because we're all going to need to sort of figure this out collectively about the best way to teach the material. I'm still going to do Mead, partly because Mead revives Skidmore, and now Skidmore becomes really important again. But I can certainly see just not doing it, summarizing it, and I can certainly see 2 or 3 years from now there no longer really being any point. So that's kind of where we are.
Can I throw one more thing at you, and then we'll open up? I guess it's just I do this for legislation regulation, the first year course, thinking about this material quite differently than if my upper year administrative law course. Some of you may not teach both, so this is your one chance to cover all this material, and then you want to be greedy and you want to cover everything. It's going to be hard this year to figure out the line between what do you do in legislation regulation, what do you save for an upper level course. They've all heard about Loper Bright. They've all heard about the major questions doctrine. It's pretty hard not to talk about it. So this is a question that I have, and it's going to be a little bit hard to manage. In the first year, I want to explain to them that there are these grand debates about the administrative state. And we've just had a term in which we've had a number of cases. I want to give a lot of context to Loper Bright and to West Virginia, because in the first year, they haven't been exposed to, let's just say on the one hand, the Gorsuchian hamburger view, and on the other hand, the more traditional, maybe, I don't know, Peter Straussian, whose ever view, defending the administrative state. So a little bit of that context, I think, is important before you sort of dive into the doctrine. Well, I would say, just judging by, Matthew having trimmed the FDA, trimmed Brown and Williamson back to a note, I think he would probably say, and I would agree, you could cut Brown and Williamson. It's a fun case and it's good, but you could cut it. And I, again, think I get Matthew's point that, Mead does raise Skidmore again, but I think, Rick, you could skip Mead and just summarize it and say that, there was a period of constraining Chevron, cutting back on it, which culminated in, ultimately, Loper. That would leap to mind. I think you have to teach Chevron itself still. I do think you have to teach Chevron.
Especially because so much of Loper Bright is devoted to why it's overruling Chevron. And if you cut everything in Loper Bright out that wasn't about why Chevron was wrong,
yeah,
like 3 paragraphs left. If that. So I think that would definitely go there. I still am planning to spend the last 3 weeks of my course, basically a quarter of the 12-week class, on what we used to call the Chevron issues, the legal interpretation of the administrative state issues. I think, though, you could do it in much less time if you didn't want to spend as much time on it. So for what it's worth, I just pulled up my syllabus, and the first week I do a day on the pre-Chevron stuff. Hearst and Skidmore are still the principal cases, and although Gray is now discussed more than it was before in the reading, and I'll probably mention it more. Then the second day is Chevron. And then the third day, I got MCI versus AT&T. And then the next week, I'm still doing Babbitt versus Sweet Home.
How long are your classes, Matthew?
80 minutes.
Yeah.
So to be clear, one of the reasons and then I am going to have a session on like other issues with application of Chevron with respect to legislative history and canons, but that's now consolidated to one class where it's just the note material without a principal case. So that's my 2 weeks on like the Chevron and Chevron era stuff, 5 classes, more than you need on doctrines that are no longer good law. I should say one of the reasons that I do that is part of my pedagogical strategy, which the Supreme Court kind of messed up with Loper Bright, is to use the last few weeks of the course to review the first few weeks of the course, because I'm teaching this as an integrated leg-reg course. I imagine many of you are too, although you could use the book as a standalone book just for ad law. And so it's useful, right? Like we talked about textualism 6 weeks ago. So let's look at textualism again in MCI, or we learned about canons and let's think about those in the context of Sweet Home and so forth. So I'm having trouble letting go of that because it was so useful pedagogically when students are starting to get nervous about the exams. So I'm still doing that, but then I transitioned to a class on Mead, a class on West Virginia, and then 2 classes on Loper Bright, which is a little bit misleading. It's more like a class and a half because I always leave some flex in the last class, for exam spiel and for wrap up and for so forth. So that's the way I've allocated it. I think one could easily distill that down to, I think you want a class in the pre-Chevron. You could do whatever you want, but like for me, the economy version, if you will, would be a class in the pre-Chevron cases, Chevron, Mead maybe, then West Virginia and Loper Bright. So I think in 4 or 5 classes, I think you could do it if you wanted to strip it down and not try to use this material as kind of like an opportunity to review the earlier material.
And Rick, I've got 4 2-hour classes on this stuff, and it tracks pretty much what he emphasized, but it's like, pre-Chevron, Chevron, post-Chevron, and, over 4 2-hour sessions.
Yeah, it's a great question. I'm teaching it again. I'm about 2/3 of the way through teaching this year, and I basically didn't change the front end of the course pretty much at all.
Me neither.
So one could, I suppose. I think, though, that at least here, it's important enough, and I think the people who teach in the upper level curriculum expect the students will have a kind of basic grounding in statutory interpretation, theory, and practice and debates and so forth, that I was not inclined to cut back on that. One always could if you wanted to make space, right? Like I spend, 3 or 4 weeks on just the statutory construction stuff, and you could easily do it in less time and still give the students the fundamentals. Like I paused to throw in some cases that I think are like fun and cool and interesting that are not, strictly speaking, essential. I have a soft spot, for example, for Spectre versus Norwegian Cruise Lines. I may be the only person.
I never teach it, never.
I love
Okay.
that case. It's so interesting, but that's like the bonus extra super challenge capstone thing at the end. You don't need it. In terms of the back end of the course, I mean, again, I think it will start to become a bit clearer in a few years, frankly, as we see more courts applying the kind of Loper Bright type framework and hopefully seeing some cases where the courts are struggling with how that framework, or how its version of Skidmore respect applies in cases that also involve canons or legislative history or what have you, so that we can preserve some of what I was just describing, the kind of appealing pedagogical feature that I always liked, that we're losing a bit of, that the last part of the course really reinforces or reviews the first part of the course. But at this point, I'm not really planning any major revisions to the front end. I still think it's important, get for students to get that stuff. I'm not sure, Ali, if you're teaching in the fall or the spring, if you're teaching 1Ls or upper level students, but first semester 1Ls, the statutory interpretation stuff is a great thing to start with first semester 1Ls, right? Like, it's very intuitive in terms of the questions are very intuitive, but how to think about them is very, very challenging in a good way. So I really like leading off with that stuff.
One thing that's changed over time is when we used to teach the first part of the course, and it was sort of set up as textualism versus purposivism at some level. And then you get to the second half where it's all about, well, now we're introducing an agency into the process. And the question is, what kind of deference, how much deference, and when should agencies get? And that disrupts the straight up reading of the statute. You can now suggest that not so much. In other words, the stuff you're learning, the tools you learn in the first part of the course, it now becomes what you do all the time. The default is you interpret every statute using your textual tools if you're the modern current court. And the idea that the agency is now present is less important than it used to be, is one way of thinking about it. It makes less difference than it used to make, at least with legal interpretations. And that actually shines a new spotlight on arbitrary capricious review. So you can sort of tell a narrative here in which you say, now the question is going to be, will arbitrary capricious review still be a zone of relative deference, or will that give way also? So there's a sort of different emphasis for me in how I structure this when I talk about it.
I'd be lying if I said all of this was this summer. A lot of this is the old Chapter 5 revamp, so it's not all from scratch, but featuring a brand new Loper Bright principal case and about 20-odd pages of notes on Loper Bright at the end. Wrong about this. I think it's also just available on the Publish in the West website. I think if you go and find the website that has the book, there'll be just a thing you can click and download the new Chapter 5. But for what it's worth, I did make an editorial decision not to include an extended discussion of the pre-1940s case law. There's a paragraph or so on it saying this debate goes back to the beginning, and then I cite Bomzai and I cite Craig Green, who does a nice critique of Bomzai and like a bunch of the other stuff, saying it was a big mess of thing. And then I just say, we're going to pick up the story in the 1940s. And like, here was what had kind of emerged before the APA was enacted, on the logic that maybe we might think that the standard review the ABA means, or the APA, I should say, not the ABA, the APA means to embrace, would be closely related to what the case law looked like right beforehand. So one could, if one wanted to, give students a supplemental reading, some of the older cases and maybe some of the scholarly commentary. I could easily see a faculty member who was more interested in delving into the history, providing more than what's in the book. But I just decided for the book, I'm going to just have a paragraph or two that alerts students to there's also an old case law and an active, vigorous scholarly debate about what it said or didn't say, and then just pick it up, principally with Gray v. Powell, which is the first case I talk about in the run-up to Hearst, which stays the principal case, but now there's several paragraphs and some extended quotes from Gray, especially because Gray gets discussed so prominently in Loper. I wanted to make sure that was, that the students are aware of it when they get to that discussion later. So there's not yet there's not yet an extended Loper Bright note on that particular point. They happen back to back in the casebook. So obviously, when I was revising the MQD notes, I was aware of Loper Bright and tried to approach this accordingly. So there's less discussion than there used to be about how, if at all, MQD relates to Chevron, not because it's not interesting or important, but now it's more historical. I just, as a substantive matter, putting aside like the interrelationship, I think that the MQD, there were some blog posts suggesting maybe it's not needed anymore now that Chevron's gone. I don't think that's right. I think that the version of MQD that the court seems to adopt in West Virginia and Nebraska, at least the Chiefs version and definitely Gorsuch's version, though maybe not Barrett's version, goes above and beyond, right? It's not just we interpret the statute based on what we think it means without deference to the agency. It demands a clearer expression of congressional intention to authorize, big stuff, which I think goes beyond. Now, I think that this is one of those places where I think we'll need to wait and see how things evolve. I would suspect that within a couple of years, we'll get some cases involving the MQD and how it works under Loper Bright. And I suspect that since, many administrative law professors, especially the relatively new ones, are going to be scrambling to write their Loper Bright articles, we'll get plenty of articles that address the interaction with the MQD. So as that material accumulates, I think we can expect to see, for what it's worth, I'm not thrilled about this, but more frequent supplements to the casebook, particularly Chapter 5, over the next several years, because things are just going to be coming so fast and furious. But not much.
Super simplistically, Rick, I mean, I teach, it's boiled right down. MQD is for big stuff, big, important, major things that the court deems major enough to care about. And it contains a presumption against the agency. It's not just a neutrality, like now post Chevron, you approach it with neutrality, the court decides the best interpretation. So I'm just adding to Matthew's point, which is, I think of the MQD as the presumption against the clear statement rule needed. The broad authority isn't good enough. And the court doesn't really get into significant sort of fine-grained textual interpretations weighing what's the best interpretation. It just skips it. It just says shortcut, no deference, goes back to Congress. And Matthew and I wrote a piece about this, sort of explaining in great detail different ways of reading the MQD at West Virginia. But I would just say, I always tell MQD is for big stuff and Loper is everything else, right? Your run-of-the-mill interpretation, even if it's not a significant major political case, lower court judges in every instance are going to have to wrestle with what's the best meaning of the statute in every case, no matter how small we may think it is, a fisheries case.
Mm-hmm. One thing that I've done, and I did this in the pre-Chevron world, I might do this, I'll still do this and maybe even do a little bit more, that I find is sometimes a useful classroom exercise when calling on people. Just try to get a sense of, for how many students does the standard of review make a difference, right? So when I teach MCI, I will often ask, how many of you think that the FCC's interpretation is clearly correct, such that even under Chevron, the agency ought to have, even without Chevron, the agency ought to have won? And how many people think Justice Scalia is right, that even under Chevron, the agency ought to have lost? And how many of you think that it's, under Chevron, the agency should have won, but without it should have lost, and so forth? And I usually get a good chunk of people in that last group, which I think is helpful, right? Because students sometimes, they got a standard of review, like who really cares? They're going to do what they're going to do. And I think it's sometimes helpful for at least some students to themselves feel like it matters to them, and for at least other students to see it matters to their classmates. And that's why, although I haven't gotten to it yet, I'm at least tentatively planning when we get to Loper Bright to raise questions like, okay, let's go back to Chevron itself. If Chevron hadn't announced the Chevron standard was revised or, evaluated under Loper Bright, would that change the outcome? Or in a case like Babbitt versus Sweet Home, right? Does it make a difference if we're evaluating this pursuant to like Skidmore respect, but independent judgment? Do the arguments that the dissent made in that case, based on terms of art and nos cautere socius, mean that like the better interpretation of the statute is that habitat modification is not a taking? And what I'm hoping we'll get out of that is, again, just to drive home to the students, and this might be especially so for 1Ls, why this standard of review thing matters, which again might be completely intuitive to all of us, but isn't always completely intuitive to first semester 1Ls.
Matthew, you had mentioned that you will pass along your syllabus.
Happy to.
Thank you. And we'll share that with others. Because I think that could be really helpful as people are thinking about their class in the semester, or even the end of this semester. But I just thank you so much for taking time to do this. Jody, thank you so much. And everybody on the call, I really appreciate it. I hope this has been helpful. It has been incredibly insightful on my side of things. I really appreciate all the work that you have done. So thank you.